This has to do with his hush money payment conviction. You'll remember the conviction is still operative. It's still on the table. Well, today, a judge there, the judge in the case all along, rejected Trump's argument that a recent Supreme Court ruling had nullified his criminal case in New York, upholding the former and future president's felony conviction for falsifying records to cover up a sex scandal with porn star Stormy Daniels. Let's talk about this with our friend, legal analyst Randy Zelin. He joins me. And Randy, good to see you here. I guess, I don't know if you want to call this a bow on this particular story. We know the sentencing in this case has been indefinitely delayed and postponed now that Trump will enter the Oval Office January 20th of next year. But some of the arguments the Trump legal team was putting forth about vacating the conviction entirely rested on that question that you and I have discussed so often about presidential immunity. Judge Juan Merchan in the case today in this ruling saying, doesn't matter in this. Why?
What the court did was essentially look at the evidence in total and essentially said, okay, let's assume for argument's sake, we take the Supreme Court decision, we look at the three possibilities, you get absolute immunity from those constitutional duties that you have as president, you get presumptive immunity from those official acts. Let's assume for the moment that some of the things that went on took place while Mr. Trump was president. However, since the payment itself took place beforehand, that is clearly an unofficial act. And the evidence was so overwhelming that even if the jury heard evidence that it shouldn't have, because it fell under this umbrella of presumptive immunity, the evidence was so overwhelming, it doesn't really matter. And I think that that is the fundamental flaw in the court's reasoning.
Okay, so just because a conviction may stand doesn't necessarily mean whatever the jury rendered in the hush money payments trial, 34 felony counts of falsifying business records, the guilt is still there, right? I mean, the conviction is still in place, but
it is there for the moment. But the question is going to be, since, by the way, it's typically the appellate court that determines whether or not error was harmless. And here, Justice Merchan saying, well, if the jury heard evidence that it shouldn't have because it would have been protected under presumptive immunity, it's no big deal. The evidence was overwhelming. That's really for the appellate court to weigh in on. And the appellate court has to determine that President Trump, now president, former president at the time, that he was deprived of a fair trial. And I would respectfully submit that any evidence that the jury heard that it shouldn't have, because a hearing should have been held, assuming that that decision had come down before the trial, the Supreme Court weighing in on presidential immunity, had a hearing been held and the court determined that a lot of that evidence shouldn't have come in, I think that the former president, now president, was in fact deprived of a fair trial. And I think the appellate division will end up throwing out the conviction.
Okay, do you anticipate that will happen soon, or will President-elect Donald Trump serve a full 4-year term? And could this happen in 2029 and beyond, Randy?
Well, it's interesting because right now there's still another motion on the table, which is whether or not the court should dismiss and basically vacate the conviction because President-elect Trump is going to be president. So that's an argument that still has yet to be decided. And then there is this kind of odd notion. Does the court say, okay, tell you what, we're going to leave things as they are. I'm not going to sentence President Trump now. I'm going to sentence him when he leaves office in 2029. So it is possible that this can get kicked down the road for the better part of 5 years and let the court figure out what to do then. But again, I suspect here that the appellate division at some point is going to weigh in because, truth be told, Andrew, the country has spoken.
Yeah, no, that's true, Randy, and that's a political consideration. But I think people watching this, viewers, they're scratching their heads. How can you freeze in place a conviction without rendering any penalty phase and then pick it back up XYZ years later?
There's no precedent for this because never in the history of our country, as President Trump likes to say, never in our history
Yeah.
has a president, whether a former president, a president-elect, a sitting president, ever been convicted of a crime, let alone 34 felonies. So we are in completely uncharted territory. But I do think that Justice Merchan should vacate the conviction. This country should get a clean slate and a clean start. We don't need a president with 34 felony convictions.
I mean, to your point, he would be the first incoming president to have a felony conviction, i.e., be a felon here. I mean,
Nobody cares.
But do you anticipate a conviction vacation while he's president? I mean, is Merchan going to take this up speedily, or does this have to get to a higher court in New York?
I sense, I don't know that the court is going to now look at the second motion, which is that the conviction should be vacated because he's now president, though Justice Merchan could surprise us and vacate it on those grounds, which I think would be great. But if he doesn't, it will be for the appellate court to weigh in. And I would think that we would probably have a decision on that, unless it could be fast-tracked somehow, probably within a year to 18 months. But we do need some resolution, and we really do need to close the book and move forward.
I guess my question was, do you think that's going to happen before January 20th? It doesn't seem like you do. Randy Zelin, as always, can't thank you enough. You've really provided such great insight. Now, over more than a year of this case and this trial and this conviction, and we'll talk soon.
Thank you.
All right, in the meantime here, so just wanted to make sure we got that in. That broke earlier this afternoon here, and that was the news today. Prosecutors there had argued that the Supreme Court's immunity decision on that presidential question had, quote, no bearing on this prosecution, noting Trump was convicted of orchestrating a scheme involving a personal and political crisis that predated his presidency. Now, you'll remember that question of presidential immunity. The Supreme Court had to grapple with private acts and official public acts that an executive undertakes. So, wanted to get that in there as well.